We begin with the conference with our keynote speaker, Sir Geoffrey Nice, QC, Chair of the Uyghur Tribunal, has been a barrister since 1971 and served as a part-time judge in England between 1984 and 2018. Between 1998 and 2006, he led the prosecution of Slobodan Milosevic at the UN International Criminal Tribunal for the former Yugoslavia. He was Gresham College Professor of Law from 2012 to 2016 and was chair of the China Tribunal. Please welcome Sir Geoffrey.
Well, thank you very much indeed for inviting me and allowing me to speak and allowing me to leave after 20 minutes because I have to catch the last train home to avoid sleeping on the streets of London. But although I will leave you, you're in admirable hands because Hamid Sabi, who is with us, is or was counsel to the Uyghur Tribunal, but more important, he's the person who introduced me 7 or 8 years ago to people's tribunals. I didn't think much of them when he introduced me, and I took a rather distant view of them, but by the end, I could see that his particular tribunal, which concerned events in Iran in the late 1980s, had some very considerable advantages. And so he's the ideal person to take over from me and answer questions when I'm gone. After that first tribunal, I worked on another much less satisfactory tribunal, in my opinion, which, although it was effective in the setting in which it operated, I thought was unsatisfactory in various ways. Lessons learned from those two tribunals were applied by me when I chaired first the China Tribunal into forced organ harvesting of prisoners of conscience by the PRC, but principally forced organ harvesting of Falun Gong practitioners, and then more recently of the Uyghur Tribunal. Now, People's Tribunals have the same general title, People's Tribunals, and they're not at all similar. They're very different, one from the next, and it's important to bear that in mind. They have one thing in common, namely that they provide information or answers to questions that aren't being dealt with by national or international bodies when they could or should be. But apart from having that feature in common, it's important to realize that they can be very, very different in what they seek to do. At one end of the scale, they can be highly activist organizations. At the other end of the scale, they can be completely non-activist. And so far as the Uyghur Tribunal is concerned, we were and are not activist. Why? Well, if you look at the work of civil society in the most general setting or general terms, the work of citizens who are not parliamentarians, they're not in government, they don't have official function. They can do various things, but until such time as society or international society is ready for revolution, the best thing, you may think, is for them to try and help the functioning parts of national or international society, including courts, that could do things better. And that is certainly what really underlies, I suppose, the way the Uyghur Tribunal operated. And I think I've got about 11 or 12 points, each of them a very short sentence, but that would now be principles I would apply on the basis of my experience. First, a People's Tribunal of the kind I have chaired needs to be commissioned by an interested organization, an activist organization, in this case, the World Uyghur Congress. Second, having been commissioned, and of course the commissioning body will have to provide necessary funds, although all members of the tribunal are completely unpaid and not allowed to put money in, having been commissioned, it's necessary that there is a separation of functions and that the commissioning NGO recognizes that the tribunal may not reach the conclusion the commissioning NGO wants. We're not a rubber stamp. The next thing, critically important and valuable, is to appoint disinterested people, people who aren't committed to the cause concerned. It may sound harsh, but the 9 members of the Uyghur Tribunal weren't particularly concerned about the Uyghurs, no more than they were concerned about Rohingya Muslims or Nigerian Christians who might be subject of oppression. No, our concern was the fact that there was information that was not being made available to us. The tribunal that is appointed should be diverse in background. And if you look at the composition of our tribunal, it was in discipline, as well as in gender and other diverse characteristics. Next, the tribunal should never be composed, in my view, of experts, whether lawyers or people who have the label human rights hung around their neck. Sometimes people hang that label around my neck. I never seek it. I never use it of myself. I'm just a citizen, and it's much better that I'm a citizen. I can operate as effectively a juror, for those of you familiar with jury trials. Next, having established yourself, you go and gather evidence to find out what may be proved. You do not have a prosecution's case or a legal case to try and prove. You're not there looking for crimes, first of all. You're there looking to see what the evidence actually shows. And only when you've begun to form views about what the evidence shows, do you bring the lawyers in to tell you what's the relevant law that you can apply to the facts you're finding in order to decide whether crimes have been committed. And it's very important to realize, sometimes difficult, lawyers are the servants of people. It's not the other way around. Lawyers can be over important, and you've got to be careful to keep them in check. Next, in a case like the one we were dealing with, or a situation like the one we were dealing with, invite the PRC, the People's Republic of China, to participate, which we did on many occasions. They always declined, but never allow that to be held against them. You can't draw inferences adverse to the PRC from the fact that they've been invited to participate and they haven't. Think what you would feel if a bunch of 9 people from another country did the same thing to your country. No. It would have been better if they'd participated, but they didn't. We acted on the basis of evidence we had received, not on the basis of evidence we did not receive. Next, apply both to the law, to the facts, or to proving of the facts, and to finding of the legal consequences, the strictest possible proof beyond reasonable doubt. Easy to understand in respect of factual findings, but very important for the law. Where the law is uncertain, don't venture beyond what the courts have already decided the law is. If you do that, you're on a path to a very dangerous entanglement with experts outside the conclusions you reach. Just take the law as it is clearly shown to be. And that's the way we reached our conclusion. And then the last point of great importance in my judgment is make no recommendations. Why? Because to make recommendations and tell people, governments and businesses and universities, how to run their affairs is quite an impertinence, because it assumes that people will not perform the duties they have to perform when they interact with, in this case, the People's Republic of China. It is quite enough to provide them with a reliable, dependable, well-established collection of factual and legal findings and leave them to discharge their duties. That's what we did with the Uyghur Tribunal, and it's now 11 minutes past 9.
Oh, thank you so much, Geoffrey Nice, for your leadership and your wisdom and compassion. There may be a couple of questions in the audience for you. Also with us is Mr. Hamid Sabi, counsel to the Uyghur Tribunal, and he will also be helping us with answering some questions. If you have questions for Sir Geoffrey, could you raise your hands?
It's usually the first person to ask a question that's required to break the ice. Now, come on, I'm out of here in 9 minutes' time. So one of you feel confident.
Well, what do you think, how should people respond to the judgment, and what do you think could be done about it?
Well, that's a critical question, and it's been actually quite rewarding, I think. What we would have wanted was for people to apply the judgment in decisions that they have to make. And what we have discovered in respect of the Uyghur Tribunal is that as newspaper reports deal with, for example, decisions whether or not to send people to the Olympic Games, what to do about solar panels, all sorts of other things, we find that the Uyghur Tribunal judgment by that name is mentioned. And that means that people have, amongst other things, and we are not expecting to be the cause of anything. We are an element that people should apply in the process of reasoning that we all do when we decide how to discharge the duties we have within the world and to our fellow citizens.
Yes, and there's a question from one of the MP. Was there a call for, was there an open call for evidence?
Yes. First, we have an enormous stock of evidence, which is on a computerized database, as you would expect. Evidence was gathered by Hamid Sabi and his team according to criteria that we set down that related to the allegations as we understood them in the most general terms to be. And from that computerized base, Hamid Sabi and his team selected a fair representation of evidence, always remembering that it's important, critically important, to make sure that evidence favorable to the PRC is also included. But at all times, there was an open invitation on the website for evidence to be provided, and Hamid can deal with this possibly after I've gone, but there was an open invitation to provide evidence. And as things developed, the 9 members of the tribunal themselves raised questions with Hamid Sabi as to what evidence they would like to hear, in addition to what he'd already provided.
So this question is a little bit different, but I'll go ahead and give it to you. Considering the China Tribunal, would it be necessary for one or more NGO to sponsor another tribunal to address whether the crackdown on the Falun Gong rise to the level of genocide?
Well, I don't think that's a question for me to answer, because I'm not here to tell other people what to do. In the China Tribunal, genocide was not found, although it was explained that there was indications that it might have been committed, but that there wasn't at that stage sufficient evidence. Now, if an NGO or an organization interested in the suffering of the Falun Gong and other prisoners of conscience feels that more evidence has come to light, it can do one of several things. But it shouldn't necessarily be the case that it turns straight to the idea of forming another tribunal. There may be other ways of doing it, other ways of reporting. Remember, if you would be so good, the underlying essential is not something that happens to be titled People's Tribunal. The underlying essential is to provide information in a reliable and dependable form to the community at large, national and international. And it will be for the organization concerned to decide what to do with new information it had. And I'm not going to tell people how to run their lives.
Right, fair enough. So this is from another MP. How do you respond to the charge that the tribunal is not a court?
Thank you. This comes from Nusrat Ghani. Good evening, Nusrat. Of course, it's not a court. Jolly good thing too. The whole reason for having civil society activity of this kind is that formal bodies have not done what they might or should have done. So of course we're not a court. We don't have any powers, and that's our power. If you go back to the fount of all this, which is the Russell Tribunal into the alleged criminality of the United States of America in the Vietnam War, it's a tribunal that can be criticized for many things, but it's very interesting. It's worth reading about it. It's referred to in the China Tribunal and will be referred to in one of the appendices to the Uyghur Tribunal. And in it, Jean-Paul Sartre, a very famous French philosopher of the time, who formed the tribunal with the English philosopher Lord Russell, says, we are powerless, and that is our power. Be not respectful, or at least be not over-respectful of governments and courts and parliaments, because when they fail, we, the people, can do what we do, and we can do it in whatever way we like. And if we are able to show something to the very high level of proof that we've demanded of ourselves, if we can show that, that's quite as good as a court judgment. We don't need the separation of wearing robes or having titles or having raised pedestals to sit on. Of course, the tribunal has to sit a bit higher up so that people can see them, but that's all. We are people. The clue is in the title. I'm not concerned about not being a court, Nuz. I'm really pleased about it.
So this is from an attendee. Hello, I found it quite interesting. I don't quite understand why no recommendation should be given. Wouldn't that cause the judgment of the People's Tribunal to lack persuasion force if there is no call to action? Another question.
But why would you want me to make recommendations? Why would you want the jury in a trial of a criminal, for example, to make recommendations? You have a sensible separation of functions. We are, as I explained at the beginning, a finder of dependable, reliable, proven facts. That's what we do. And we then say to you, now this is up to you. You use it, you deploy it. And that is the way things work best. And indeed, just to finish this little analogy, when a jury brings in a verdict of guilty in respect of a criminal defendant, the jury walks away. That's it. Job finished. The judge comes in to sentence. The probation service comes in. Social services come in. The National Assembly of Lawmakers comes in if the verdict has a particular effect and need for amendment of the law. It's much, much better that you confine the decision-making process of the tribunal to facts and law and leave responsibility for next steps to other people. And I see it's 9:20, so I'm getting ready to leave. And I see that Luke's looking pleased about the fact that I'm ready to leave. Hamid's looking delighted because he can answer questions and tell you all where I've gone wrong. And I can say thank you very much for letting me contribute to this discussion of yours. And I see Dolkonissa there, who is the president or president of the World Uyghur Congress. And you heard the things I said about his immaculate following of the rule of separation of functions. And unless you want more of me at the moment, I'm going to very gently withdraw by pressing a button on the screen.
Thank you so much. I would like to speak for many of us here to appreciate the work done by the Uyghur Tribunal. You who stand up against an evil empire do exist in real life, and on this day we have a chance to meet them. Thank you so much.
You're very welcome, and I look forward to hearing of the results of your discussion and maybe meeting some of you in times to come. Thank you.
Thank you, sir.
Thank you very much, sir.
Mr. Habib, are you in a position where you can answer some more questions?
Depends on the question, but please go ahead.
Okay. Has the UN engaged about your report given they were unable to access evidence themselves?
Sorry, can you repeat that? There was a...
This is from an MP. Her question is, has the UN engaged about your report given they have been unable to access evidence themselves?
The evidence that we have collected and collated is available to everybody. And of course, the judgment has been sent to all the organizations. I'm not particularly sure which part of UN has received it, but I'm sure it was given to the High Commissioner for Human Rights. The evidence is available to all organizations. There is the whole idea of the tribunal was its transparency, that everything that the tribunal has dealt with should be available to everybody so that they can use this, and also that will give them the chance to verify the content of the judgment. So in that sense, the answer is they can access the evidence if they want to.
Yes, sir. This next question is from Sir Ian Duncan Smith. The determination of genocide is important, yet the determination of genocide is rejected by the UK government. Which hides behind the need for this to decide by a relevant court, which China will veto? How do you think this will be taken forward without a court judgment?
The position of the UK government is that they would only consider the appropriately constituted courts to make that decision. They very well know that there isn't such court to make that decision presently. There is no situation where the Uyghurs or any other group can bring a case before a judge that make that decision. And the only thing that the convention imposes upon all the member states, including the United Kingdom, is that they should take all actions necessary to stop genocide. Now, there has been a finding by a tribunal on the basis of substantial evidence. Over 70 witnesses testified, thousands of documents was presented to the tribunal, 8 days of full hearings, and the conclusion is detailed in an extensive judgment. So at minimum, the UK government can now stand up and make a decision. Do they want to ignore all this evidence, or they want to take a step? The UK government put every single hurdle in front of us. We had many requests for documents from the UK government, diplomatic wires, anything that can be helpful to the tribunal. None was provided. We even made an application on the Freedom of Information Act. We did not receive anything from the UK government. So although they show some sympathy and say they are worried about the Uyghurs, they do not positively engage with the tribunal or with any other group that is investigating this matter. And it's very unfortunate.
Yes. Thank you, Mr. Sabi. And we hope that your leadership will continue to help us in further our human rights and human dignity. So our next